This is Mr. Wesley, and today we are talking about the financial ambush. Not the one you were expecting, not the division of assets, or the loss of the family home, or even the pension split that I described in an earlier video in this series. Those losses are real, and they are significant, and they deserve the serious attention I have already given them. But the financial ambush I am describing today is different from all of those. It is quieter. It is less visible in the landscape of divorce financial planning. It is the one that most men do not discover until the settlement is already signed, and the legal process is already closed, and the number is already fixed, and the consequences are already running, and it is, for a significant number of men in this demographic, the financial consequence of their divorce that takes the longest to recover from, and that causes the most sustained damage to the financial architecture of the years that remain. I am talking about marital debt. Not your debt. Not debt you incurred for purposes that were yours and that you understood and consented to as your financial obligation. The debt that was incurred inside your marriage, by both of you, or in some cases primarily by her, that the legal framework of your divorce has now made your permanent financial responsibility, regardless of who spent the money, regardless of what it was spent on, regardless of whether you knew the full extent of it when you signed the settlement agreement that made it yours. The marital debt trap is the aspect of divorce financial reality that men in this demographic are most consistently underprepared for and most consistently blindsided by, not because the information is hidden. It is available in the legal and financial literature for anyone who knows to look for it, but because most men approaching a divorce are focused on the asset division, the house, the retirement accounts, the pension, the savings, and are not running an equivalent level of scrutiny on the liability side of the marital balance sheet. They are negotiating over what they get to keep without fully accounting for what they are agreeing to owe. And the gap between those two analyses, between the asset negotiation they conducted carefully and the liability analysis they conducted inadequately or not at all, is where the debt trap lives. In a few minutes, I am going to walk you through the specific mechanisms by which marital debt becomes a post-divorce financial catastrophe for men who did not see it coming, the specific types of debt that are most commonly involved, the specific legal frameworks that determine how that debt is allocated, and what those frameworks mean practically for your ongoing financial obligations, and the specific decisions that men make during the divorce process that most dramatically affect whether the debt trap closes on them or whether they navigate past it with their financial position intact. There is one specific decision in particular, one that most men either do not know they can make or that they make incorrectly under the pressure of a settlement negotiation, that I want to make sure you have clearly before this video ends. But first, you need to understand how marital debt works in the legal framework of divorce, and why that framework produces outcomes that most men in the middle of a settlement negotiation do not fully anticipate. I am Mr. Wesley. I have spent years working alongside men who emerged from divorce settlements with financial obligations they had not fully understood when they agreed to them. Men who had negotiated in good faith, who had accepted what appeared to be equitable arrangements, and who discovered months or years later that the arrangement they had agreed to contained a liability dimension that was running quietly in the background, accumulating interest and consequences in ways that their settlement negotiation had not accounted for with sufficient precision. This is Relational Insights, and this is the financial clarity that most men do not receive until it is significantly more expensive to receive it. Let me open the liability side of the ledger. The foundational concept you need to understand is the distinction between internal debt allocation and external debt obligation. This distinction is the gap through which the debt trap opens, and it is the gap that most men in divorce settlements do not see clearly until they have already fallen through it. When a divorce settlement allocates debt between the two parties, when the settlement agreement says that she is responsible for the credit card balance and he is responsible for the home equity line of credit, that allocation is an agreement between the two divorcing parties. It is an internal agreement. It is enforceable between them through the family court that issued the divorce decree. But it is not binding on the creditors who are owed the debt. The bank that issued the credit card does not recognize the divorce settlement as a modification of the original credit agreement. The financial institution that holds the home equity line does not care what the divorce settlement says about who is responsible for the balance. What the creditor recognizes is the original credit agreement, which in most cases was signed by both parties, and which makes both parties jointly and severally liable for the full balance regardless of what any subsequent agreement between those parties says about their internal allocation of responsibility. This means that when a divorce settlement allocates a jointly held debt to one party and that party fails to pay it, whether through financial difficulty, through deliberate non-payment, or through the simple practical reality that a person whose financial life has been restructured by a divorce may not be able to sustain the payment obligations the settlement assumed they could sustain, the creditor has the full legal right to pursue the other party for the entire balance, The divorce settlement gave you the right to pursue her through the family court if she fails to pay the debt that was allocated to her. It did not give you protection from the creditor who is pursuing you for the debt that was originally in both your names. Picture this. There is a man I know, I will call him Franklin, who went through a divorce at 61 after a marriage of 23 years. The settlement negotiation was difficult and long, but Franklin felt, when it was concluded, that the arrangement was broadly equitable. The asset division had been contentious, but had produced an outcome he could live with. The debt allocation had received considerably less attention during the negotiation. It had been addressed in the final stages of the process, when both parties were exhausted by the length and the cost of the proceeding, and were primarily focused on closing the settlement and moving forward. Franklin's ex-wife was allocated responsibility for 2 joint credit card accounts totaling approximately $42,000, and a personal line of credit in her name alone that had been used primarily for household expenses during the marriage. Franklin was allocated responsibility for the home equity line of credit and 1 additional credit card. 14 months after the settlement was finalized, Franklin received a collection notice from one of the credit card companies for which his ex-wife had been allocated responsibility in the settlement. She had not made payments on the account for 11 months. The account had gone to collections. The collection agency was pursuing Franklin for the full balance plus accumulated interest and fees, a total of approximately $28,000. Franklin contacted his divorce attorney, who confirmed what I have just described to you. The creditor was not bound by the divorce settlement's internal allocation. Franklin had the right to pursue his ex-wife through the family court for reimbursement, but the creditor had the right to pursue him for the balance. In the meantime, the collection activity was going on his credit report, the balance was accruing additional fees, and the family court process for recovering the amount from his ex-wife was itself time-consuming and expensive and uncertain in its outcome given her financial situation at the time. Franklin told me that the $28,000 collection notice felt like a different kind of loss than anything else the divorce had produced. Not because it was the largest financial loss of the divorce, it was not, but because it arrived after he had believed the financial exposure of the divorce was closed. He had signed the settlement. He had accepted the terms. He had moved forward under the assumption that the liability dimension of the divorce had been addressed in the settlement in a way that was complete and final. The collection notice told him that assumption had been wrong, and the specific quality of financial shock that comes from discovering an ongoing liability you believed was closed is different from, and in some ways harder to absorb, than the financial losses you anticipated and planned for. Franklin's situation is not unusual. The pattern I have just described, a divorce settlement that allocates jointly held debt to one party, that party's subsequent failure to service the debt, and the creditor's pursuit of the other party for the balance, is one of the most consistently reported post-divorce financial problems among men in this demographic. And it is one of the most consistently preventable if the man in the settlement negotiation knows to look for it and knows what to ask for before the settlement is signed. Let me give you the second mechanism of the debt trap because it operates differently from the first and catches a different category of men. The second mechanism involves debt that was incurred during the marriage without the full knowledge of both parties. This is the version of the debt trap that produces the largest shock, because it involves discovering, either during the divorce process or in the months following it, that the financial life of the marriage contained obligations that were not visible in the joint financial picture that both parties believed they were operating from. Hidden marital debt, debt incurred by one party during the marriage in ways that were not fully disclosed to or understood by the other, is more common in marriages approaching divorce than most people expect. This is not always deliberate deception. It is sometimes the accumulated consequence of financial management patterns that developed gradually in a marriage where one party had primary responsibility for the household finances. Patterns of credit use, of balance transfers, of lines of credit drawn down and not repaid, that the other party was aware of in general terms, but not in specific amounts. And it is sometimes deliberate. A spouse who is aware that a divorce is approaching, and who is drawing down lines of credit or accumulating debt in the period before the divorce is filed, is engaging in a behavior that family courts recognize and can address, but that can only be addressed if the other party knows to look for it and presents the evidence in a timely way. The practical implication of this for men approaching a divorce is specific and urgent. A full and forensic accounting of all marital debt, not just the debt you know about, not just the joint accounts you can see on your shared credit monitoring, but a comprehensive search for all financial obligations that may exist in either party's name that were incurred during the marriage, is not optional. It is one of the most important steps in protecting your financial position in a divorce settlement. The certified divorce financial analyst I mentioned in an earlier video is the specialist whose expertise is most directly relevant to this specific task. A comprehensive marital debt audit, conducted by a qualified financial specialist with access to full credit bureau reporting on both parties, is the tool that identifies hidden debt before it becomes your liability rather than after. The third mechanism of the debt trap is the most structurally complex and the most difficult to navigate without specific legal and financial expertise. It involves the interaction between marital debt allocation and the specific legal structures of the debt instruments involved. Not all jointly held debt is created equal in its divisibility and its post-divorce risk profile. A joint credit card balance is divisible in principle. The account can be closed, the balance transferred to individual accounts in each party's name, and the ongoing liability genuinely separated. A joint mortgage is significantly more difficult to divide cleanly. The standard mechanism for removing one party from a joint mortgage is refinancing in the remaining party's name alone, which requires that party to qualify for the refinancing on the basis of their individual credit and income profile, which is frequently more challenging in the post-divorce period than it was during the marriage. A co-signed loan, a loan for which one party is the primary borrower and the other is the CO signer, is structured in a way that makes the CO signer's liability essentially permanent, unless the primary borrower refinances the loan in their name alone, which requires the same individual qualification that joint mortgage refinancing requires. The practical risk profile of each of these debt structures is different, and the settlement analysis that addresses them adequately needs to account for those differences with specificity. A settlement that allocates a joint mortgage to one party without ensuring that party's ability to refinance within a defined timeline, or without establishing a legal mechanism for the other party's protection if the refinancing does not occur, is a settlement that leaves the non-retaining party with ongoing exposure to a joint liability that the settlement was supposed to resolve. This specific scenario, one party retaining the family home and the joint mortgage, the other party's name remaining on the mortgage because the refinancing did not occur, and the first party's subsequent payment difficulties creating credit and legal exposure for the second, is among the most commonly reported post-divorce financial problems for men in this demographic, and it is almost entirely preventable with the right structure in the settlement agreement. Let me give you the framework that is actually useful. These are the 5 specific protections that a man negotiating a divorce settlement that involves marital debt should ensure are present in the settlement agreement before he signs it, not aspirationally, as non-negotiable terms of any settlement he is willing to execute. The first protection is the full debt audit before any settlement terms are finalized, not partial, not the debts you both know about. Full. Both parties' complete credit reports, all accounts in both names and either name individually, all co-signed obligations, all lines of credit whether drawn or undrawn. The audit is conducted before the settlement negotiation reaches the debt allocation stage, and its findings are the basis for that allocation. Any debt that surfaces after the settlement is signed, because it was not identified during this process, is a liability that could have been avoided with adequate upfront diligence. The second protection is the distinction in the settlement agreement between internal allocation and external liability. The settlement should not merely allocate which party is responsible for which debt. It should include a hold harmless and indemnification clause that requires the party who has been allocated a specific debt to hold the other party harmless from any claim, collection action, or credit damage arising from their failure to service that debt as required. This clause does not prevent the creditor from pursuing the non-allocated party. Nothing in the settlement can do that, but it creates a clear and enforceable legal basis for the non-allocated party to recover from the allocated party any costs, damages, or losses arising from the allocated party's failure to pay. And it establishes that basis in the settlement agreement itself, rather than requiring a separate legal proceeding to establish it. The third protection is the timeline and mechanism for resolving joint debt instruments. For every jointly held debt that is allocated to one party, every joint credit card, every joint line of credit, every joint mortgage or co-signed loan, the settlement agreement should specify a defined timeline within which the allocated party will take the steps necessary to remove the other party's name from the obligation, and should specify the legal and financial consequences of failing to meet that timeline. Not a vague aspiration to refinance when possible. A defined deadline, with defined consequences and defined remedies available to the non-retaining party if the deadline is not met. The fourth protection is the post-settlement credit monitoring agreement. Both parties agree in the settlement to ongoing credit monitoring on the jointly held obligations that have been allocated, and to immediate notification of the other party of any delinquency or collection action on those obligations. The non-allocated party's right to cure, to make payments on the allocated debt in order to protect their credit and their legal position if the allocated party fails to pay, should be established in the settlement agreement, along with the non-allocated party's right to recovery of those cure payments from the allocated party. The fifth protection is the engagement of a certified divorce financial analyst before the settlement is signed. Not after, before. The CDFA's role in the debt context is specifically to model the post-divorce financial positions of both parties under the proposed settlement terms, including the liability dimension of those terms, and to identify structural vulnerabilities in the debt allocation that the parties and their attorneys may not have identified. The attorney is responsible for the legal adequacy of the settlement. The CDFA is responsible for the financial adequacy of it. Both forms of adequacy are necessary, and neither is a substitute for the other. I want to stay with you here for a moment because I am aware that for some of the men listening to this, the information I am giving you today is arriving after the settlement has already been signed, after the process has already closed, after the exposure I am describing has already been created by a settlement agreement that did not contain the protections I have just outlined. If that is your situation, I want to address it directly, rather than leaving you with a framework that applies to a decision that is already behind you. The settlement is signed. The exposure exists. The question is what you do with that reality from this point forward. The first thing is to understand your current exposure precisely. Pull your complete credit report now if you have not done so recently. Identify every jointly held obligation that appears on it. Verify that the obligations allocated to your ex-wife in the settlement are being serviced as required. Do not assume they are. Verify it. The earlier you identify a payment problem on a jointly held obligation, the more options you have available to you for managing the consequences. The later you identify it, the more limited those options become. The second thing is to review the indemnification and hold harmless provisions of your settlement agreement with your attorney and understand precisely what legal remedies are available to you in the event that a jointly held obligation allocated to your ex-wife goes into delinquency or collection. The earlier you understand your available remedies, the earlier you can activate them if the need arises. The third thing is to consult with a financial advisor about the steps you can take to reduce your ongoing exposure on jointly held obligations. Whether that means negotiating directly with creditors to separate joint accounts, whether that means monitoring and managing the credit impact of any delinquencies that occur, whether that means establishing reserves to address the possibility of cure payments becoming necessary. The goal is to move from reactive exposure management to proactive exposure reduction as quickly and as completely as your post-divorce financial situation permits. The debt trap is real. For some of the men in this room, it is already closed. For others, it is open, and the negotiation that will determine whether it closes on them or not is still ahead. For both groups, the information in this video is the beginning of navigating it rather than being navigated by it. Because the trap, once it is visible, is significantly more navigable than it is when it is invisible. And visibility, the specific and honest visibility of your actual financial situation, including its liability dimension, is what this channel exists to give you. The most expensive signature a man can put on a divorce settlement is the one he puts on it without understanding what he is agreeing to owe. Drop a comment. Men, did the debt dimension of your divorce settlement surprise you? And if it did, what was the specific thing you wish you had known before the settlement was signed? Subscribe to Relational Insights. Every week, Mr. Wesley breaks down the hidden financial and relational realities of late marriage failure and divorce, with the precision and the honesty that finally gives men the complete picture before the decisions that shape the rest of their lives are made.